lawyer, real estate agent for probably since 1984. So I guess that brings me to 40 years, right? And during that time, I have taught for RAMP. I have represented agents and brokers and buyers and sellers in all kinds of litigation matters, as well as transactionally and in real estate. So I have actually been following the developing cases that led to the recent NAR settlement for several years. 2018, 2019 was first. And in order to understand where this came from, we need to go back to antitrust laws. The Sherman Act of 1890, the Federal Trade Commission Act, and the Clayton Act, both of 1914, were the laws that have been used by the federal government to prevent businesses from doing things that are anti-competitive. Time agreements, predatory pricing, and mergers which could lessen competition, or create a monopoly. And basically, these concepts have been used to stop mergers and break up all kinds of efforts. When big cable companies or auto manufacturers or airlines has been the most common one recently, right? JetBlue wanted to merge with Spirit, and they say, no, you can't do that. It's anti-competitive. We need that competition to create free market prices in a free market economy. So that's kind of the driving force behind those laws. And NAR and member brokers all over the country have been facing these actions for several years, alleging that any multi-list that tries to set or even create guidelines for commissions is an anti-competitive monopoly that is unfair to consumers. So yeah, lawyers have faced this too. The bar associations set guidelines for many, many years for estate administration. And it was pricing based upon percentages. So it would be 10% of a small estate under 50,000 or 5% of an estate over that. And those are the guidelines suggested by the bar. And government said, no, the bar associations are creating an anti-competitive component that is unfair to the public. Because whatever lawyer you go to, you got the same pricing schedule. And most of us are members of the bar. That sound kind of familiar to what we're talking about with real estate agents? Sure. Leader versus NAR. In the Northern District of Illinois was scheduled for the trial to start April of 2024. The 2021 case was supposed to go April of 2024. Other cases have been filed as soon as we saw a $1.8 billion verdict in the Burnett case, late 2023, prosecution lawyers all over the country knows. Have any of you seen the ads for Camp Lejeune? Right? Have any of you not seen the ads for Camp Lejeune? Okay, the water there was bad for a long time. And now there are all these law firms running ads saying, hey, come on, if you or anybody in your family or your parents or somebody were at Camp Lejeune from 1950 something to 1970 something, let us be your lawyers and file your case. So the idea is, this is what was happening. That $1.8 billion verdict got the attention of almost every class action lawyer all over the country. And remember, these complaints that were filed against NAR and major brokers were a blueprint, right? It's kind of like for you guys having the answer. All you need to do is fill in the blanks, right? Well, for these lawyers, the complaints that resulted in the $1.8 billion verdict, and I say complaints because there were a couple cases that were consolidated, so there was more than one complaint, created a blueprint that they could file anywhere and create another class and claim the same kinds of damages. Now, Gibson was just filed in 23 in the Western District of Missouri. So you have all these cases all over against NAR and against every major broker. What do they do? Not to get political about it, but whenever you're facing an onslaught of a whole lot of lawsuits, it takes your attention away from all the things you would rather be doing, from all the things that you should be doing, from all of the things that you should have a right to do. And all of a sudden, all you have to do is focus on your lawsuits. Just like in the Trump New York civil case, there was this massive judgment. And if Trump wanted to appeal that judgment and keep his New York properties, he had to post this really huge bond to guarantee, and bonds are good, to guarantee that the people who won a judgment are going to get paid. So it has to be enough money to cover the judgment, the interest on the judgment, all the additional legal fees that are going to happen during the appeals, all of the interest that continues to run during that whole process. So $1.8 billion. How much would NAR have to put up as a bond to secure that? Probably around $2.5 billion. Does NAR have that money lying around? No. It would have completely shut down NAR. And on top of it, all these other cases are going. So while they're appealing that case, they put every last penny that they have into that case. They have to be hiring lawyers in Illinois and in the Western District of Missouri and all these other places to fight all these other lawsuits. I will be the first to tell you that legal fees are not cheap. My rate's over $400 an hour. I don't get over $400 an hour. It covers all of our operations, right? If you have a 5% commission on a real estate deal, when you walk out with a check for 5%. Yeah, it would be nice, but the idea is it's very expensive to hire lawyers in all those places, whole teams of lawyers. You know, yesterday I was in one deposition in a case filed by the Attorney General's office against my client in State College over rentals. And the whole deposition yesterday was about whether it is fair and reasonable for college housing that so many of the students lose a substantial chunk of their security deposits because their apartments aren't clean. Now, I remember when I couldn't bring the rug home from my frat house room, I had to put it in the dumpster when I graduated. Okay? You know, hopefully, as we get older and more mature, we get more responsible and learn to keep things clean. But college students very often have repairs and cleaning and things like replacement of carpets due to wax and burn marks and other things. So it's not like this was an egregious thing. Yeah, yesterday's deposition alone was over $2,000 in legal fees. Our client has spent over $100,000 in legal fees, and we're heading to trial in late October, early November for 10 days of trial. So it's very painful. Fortunately, our client has over 300 properties in State College, so even though we're taking a real chunk of his profits, he's not corrupt. But, you know, the problem comes, not only are there all these lawsuits that NAR is facing as a result of this, but there's also a Department of Justice antitrust investigation. Class action lawyers are counting on a contingent fee. Like the AG in my case in State College, the Department of Justice are on salary. It doesn't cost the government anything other than the salaries that they're regularly paying to proceed with those cases. But, and you can see, one case could bankrupt NAR. Imagine 30, 40 of those cases. All with different classes of consumers over different periods of time, all alleging what? That the setting of a particular percentage commission that is established by a multi-list or a board of realtors and promoted by advertising so that buyer agents know the BAC before they show a property is anti-competitive. That's the argument.
What does that mean?
Well,
Did you fix your power of disability?
sorry, I was carrying you stuff.
That's all right. I'll be your dad.
Yeah, it's probably a little funny not saying thank you. So in any event, what does it mean? It means that consumers are arguably paying more than they would if those rates weren't set. That's in a nutshell.
Wait, I'm sorry, excuse me, weren't set or weren't advertised?
Well, setting is the anti-competitive process. Advertising is the way that the anti-competitive process reaches all the other agents. And it's interesting because neither these lawyers nor these judges are real estate brokers or agents. So they have an idea, they have a concept of what the harm is. And they have a concept of what they can do to fix it. The problem is most decisions, most settlements, most statutes and regulations are either over-inclusive, meaning the harm is here, but what they do is so much more. Or they're under-inclusive. The harm is great, and all they do is fix a small part of it. And you're going to see as we go through this, that there are a lot of ways in which the settlement really didn't reach what they were intending. So in some ways, it's under-inclusive. And it also will have effects that they didn't intend for it to have. And in those ways, it's over-inclusive. So this settlement is actually both under-inclusive and over-inclusive at the same time. Yes.
So I guess where I'm confused is, we already have laws that managing brokers couldn't discuss their commissions and say, hey, we're gonna charge this commission on this region. So how is this different from what was already covered?
It's different because those were each specific ethical guidelines, rules, and regulations. A rule, regulation, a statute ends up getting interpreted by courts when somebody comes to court. And what they did is they said these statutes and regulations aren't enough. Those statutes and regulations that are in place haven't stopped the anti-competitive result. And so they violate these antitrust laws. Okay, and they filed a lawsuit bringing the antitrust laws into it on top of those existing rules and regulations. That was a big question. So, who were the parties? Burnett is the case itself. Reality Holdings, and you know that's Global Banker, but it's also a couple of other.
Sotheby's.
Yeah,
721.
Century 21 and ERA, I think is still under the umbrella, right? So Realty, HSA, BHH, which is Berkshire Hathaway, HSF, I didn't recognize. They might not, they're not in this area, right? Remax, of course, and Color Williams, all named defendants in this action. Shotgun approach. Why are there different brokers named in different ones of these big lawsuits? Because not every broker has market size in every jurisdiction. This, of course, is the Western District of Missouri. So who's there and who's not? Companion case from the Northern District of Illinois included all those same companies, but also Long and Foster, because in Northern Illinois, Long and Foster was a big firm. So those cases actually went to trial. Now notice, I said I've been following these since like 2018, 2019. This one is a 2019 case. It's been around that long. It had been moving through the court. Now, nothing moved very fast in 20 or 21 due to COVID. You know, courts were largely closed to big things, as well as the little things like evictions. But Burnett goes to trial, October 2023. It's a jury trial. A jury is convinced that these particular practices, the setting and advertising of buyer agent commissions paid by sellers, constituted an illegal price fixing scheme to inflate real estate. The jury thought that the individual consumers who were members of the class should share $1.8 billion in refunds from that illegal price scheme. Now, could NAR have appealed that? Absolutely positively. Problem is, if they went to appeal, they'd have to post the bond. If they have to post the bond, that alone would bankrupt them. So they ended up getting into a settlement. Some of the other defendants had settled already. Rheology settled before the trial. So, the KW settled, so that KW was in it in the trial. Yeah, absolutely. And the bottom line is, it really didn't matter if anybody else settled individually, because they were going after NAR. NAR and other defendants filed post-trial motion saying things got into the jury that shouldn't have gotten into the jury. And again, not to get political about it, but I assume some of you have been following that trial that's happened in New York recently, and how some really juicy testimony about encounters between Trump and Stormy Daniels all got into the trial, and the jury got to hear all that. That was probably the most interesting days of trial, frankly, for those jurors. But on the other hand, what did that have to do with whether a crime was committed? Post-trial motions, no doubt, will be filed on behalf of Trump, saying none of that stuff should have gotten in. But once it gets in and the jury hears it, that jury can't unhear it. Frankly, I couldn't unhear or unread some of the stuff I read about what she said. You know, and should those things get in or not? At the time of any trial, it's up to a trial judge. But post-trial motions, the trial judge is asked to reconsider whether they should have let it in or not, and then that serves as a basis for an appeal when an appellate court gets to decide whether the judge was right or not. So let everything in or not let things in. And all of that's a process that takes a lot of time, a lot of money. Paying that judgment of $1.8 million would have bankrupted NAR even before any of those other cases were tried. Appealing the bond would have been way more than the judgment, and they couldn't do that. So the only alternative that NAR had to be able to survive was to settle and find a way to expand that settlement so that it stopped all the copycat cases, all the other pending cases, and allowed NAR to get back to being a trade organization and not just a defendant in a whole bunch of lawsuits. Same thing for all the big brothers. And it could have bankrupted many. So NAR agreed to pay $418 million spread out over 3 years. It's actually 4 years because they have a year in payments, so it's 3 more payments over 4 years, as well as to change its practices regarding commissions, and very particularly drilling right down the practices of the multi. And I gave you guys a copy of this PowerPoint.
I have it, yep.
You can share it with them. You take pictures. You don't have to do that.
Appreciate it, yeah.
Change practices regarding commissions and the multi-lists owned directly by the member boards. Now, in many jurisdictions, the Board of Realtors, like the Realtors Association here, RAMP, would own the board. The multi-list, it would own the multi-list. Here, RAMP doesn't own the multi-list. Brokers. But RAMP is an affiliate of NAR. And so what they did is they said the local affiliates, state affiliates, NAR, and the multi-lists owned by those local realtors associations that are part of NAR are all bound by the settlement. It does not bind non-board owned multi-lists like West Ham, but set up a settlement so that those local multi-lists that are not owned by NAR local affiliates could opt in. So, what would West End multi-list opt in to a settlement that didn't happen? Because if it doesn't opt in, if it doesn't agree to be found by the terms of the settlement, those copycat lawsuits could be filed against them. They're class action lawyers in Pittsburgh. They would be delighted to take a copy of the Burnett claim, plug in West End multi-list, and make all the same allegations and file that in the U.S. District Court for the Western District of Pennsylvania. It'll be convenient, because it's right down Grant Street. So that's a problem. The copycat class action suits really are virtually guaranteed if non-NAR affiliate owned multi-lists don't sign them. Other than the money, the settlement requires a bunch of very specific things. Number one, those NAR and its member boards have to eliminate any requirement for the multi-lists that brokers or sellers offer compensation to buyer brokers or other broker representatives. Now, you'll see it keeps saying other broker representatives. Anybody know who the other broker representatives might be?
A title company,
Who's that?
a title company.
Not really a title company, because a title company can't get real estate commission. So let me ask it another way. Who else can? Yeah, attorneys. I can get commission on the sale of real estate, even without a broker's license. And frankly, that's the reason I never got a broker's license, because I didn't want to take the continuing education classes. It wouldn't do me any good, right? It wouldn't make any difference.
What about mortgage brokers?
No,
They
they
can't
can't,
collect real estate
they
commission.
can't get real estate.
Okay.
But when it says other buyer representatives, state by state, that's regulated a little different. You know, so for example, in Pennsylvania, the way I read the Real Estate Licensing and Registration Act, people who are selling or negotiating for the purchase of oil and gas rights, that's an interest in real estate. It should pretty clearly be under broker. But there are a lot of unlicensed oil and gas guys running around. There were years ago, a few years ago, like 2014, 2013, 2012, there were hundreds of them running around here, and they didn't have real estate licenses. And yet, what they were negotiating was the sale of a part of the title to real estate. And Pennsylvania courts sort of kind of said it was okay. So that's an example in Pennsylvania. That could be a buyer representative in oil and gas who is not licensed. But they want to capture everyone. Eliminating requirements that listing brokers or sellers offer compensation to buyer brokers or other representatives, either directly or through buyers. So that's this whole, what do we mean through the buyer?
I ask a question. So, like right now, there's a whole lot of wholesaling.
Yes.
So this wouldn't affect them at all.
Well, the problem with wholesaling in Pennsylvania is that the way it's done mostly is illegal.
Yes, I agree.
So if a real estate investor ties up a title by having an assignable agreement of sale, and then goes out and finds a buyer and assigns that agreement to buyer, they're actually violating relevant, because they're connecting a buyer and a seller, and they're receiving whatever they call it. An assignment fee is another name for commission, and railroad doesn't care what you call it, they care what it is. If you receive any form of compensation for connecting a buyer and a seller in a transaction, you're not a principal and you are by definition practicing real estate. So the way that's being done violates the law anyway. On top of that, Pennsylvania has this weird rule that when you assign an agreement of sale, there's a second set of transfer taxes. So every time our settlement company sees an assigned agreement of sale, we stop and say, wait a minute, we're gonna have to collect a second set of transfer taxes on this if it's done this way. If you can get the seller to conditionally release the agreement of sale and do a new agreement of sale directly to the end buyer, then there's only one set of transfer taxes, but otherwise we have to collect two. And so wholesaling has both of those problems that are largely ignored until usually what happens is a buyer complains or an agent who was dealing with a buyer complains. And it goes either through the Consumer Protection Division of the Attorney General's office when a buyer complains, or it goes through the Real Estate Commission when an agent complains.
So right now, just on multi this, there are brokers who technically are wholesaling that are listing properties.
Well, if they're brokers, they're not violating. If they're brokers, they're not violating railroad because they're licensed. I'm talking about real estate investors wholesaling without a real estate license, without a broker's license, or without being under a broker. Those are the ones who are the violation. But the answer is if they're real estate brokers, whatever West Penn multi-list does, whatever Keller Williams does, whatever all the other major brokers do, they're going to have to follow. There's no whole new system. So eliminating the requirement that listing brokers or sellers offer compensation is very significant. The second thing is prohibiting realtor MLS participants, subscribers and others from making offers of compensation to buyer brokers on the MLS or disclosing either listing broker or combined compensation on the MLS. Basically, what they're saying is the MLS is going to become a place for information about properties, not information about commission. Notice that NAR down to local affiliates, down to their multi are who are required to follow this. But it's going to affect everything. Because to avoid copycat suits, unaffiliated multi-lists are going to do the same thing. Brokerages that haven't been sued are going to do the same thing. Brokerages that have been parties to these actions are going to be bound by their settlements. So it's going to be pervasive.
Can I ask a question? So even non-MLS sites, like, let's say a brokerage's own website.
Oh, we'll save that. It's a wonderful question. Because the answer is not what we would think. We're gonna get to that. It's right in the settlement. The next thing that's required to make sure that people don't put commission splits on by mistake, they're requiring all board-owned MLSs to eliminate all broker compensation fields on the MLS and prohibit brokers from sharing that information on other fields. Look, you could put down, let's say, where it's the square footage of the property, you could put BAC 2.5, right? Everybody would know what that meant. They say, you can't put any information about commission share, any in any field of the MLS. They have to eliminate and prohibit any requirements to participate in a realtor MLS on offering or accepting compensation, or offers of compensation to buyer brokers or representatives. You can't say, to play in my sandbox, you have to offer buyer broker compensation. What does it mean? That's interesting. There, you see, we got into this discussion of what's over-inclusive and what's under-inclusive. Preventing all these things that we're going through so far prevents standards, prevents simple, easy ways to share, but does it prevent listing brokerages from offering buyer agent compensation? It does not. They have to agree not to create facilitator support and a non-MLS mechanism. Provide the same information. So, okay. West Penn Multi-List is not gonna have this information, but there's gonna be a ramp site where you can go to ramp, press in the address of the property, and pop, all the same information. No. All the member organizations of NAR have to agree not to create facilitator support. A mechanism to get around all those key prohibitions that we just listed. But this is not violated by providing data feeds to MLS members, as long as those feeds are not used to provide a way to offer broker compensation. So bottom line is, you can send out information about listings. You just can't have any buyer agent compensation or total sharing. But look at this. I highlighted it. I figured out how to do that on the PowerPoint just for this. This is huge. And this is your question. Individual brokers, and I put the section of the settlement, Roman numeral 5D2. An individual broker can still apparently make offers of compensation to buyer brokers on its own website, only on its own listing. Now, you're gonna have to make sure that your franchisor it didn't agree not to do that in its separate settlement. But assuming that's not the case, you put it right there. So, does that really change what you're doing, or does it only change how you're doing?
My question is, can a broker set their BAC? You know, can,
You can clearly set a minimum commission. There's nothing prohibiting a minimum commission. If you set it, you have to make sure that it's not set in a way that's done in cooperation with other brokers to get around this. So the answer, in my opinion, is yes, but very, very carefully asking the New York lawyers who represented KW in these lawsuits to approve exactly the way you're doing. And look, that's no different. You remember years ago, we had all these affiliated business arrangement settlement companies where, I don't know how many of you have been practiced that long, but I had 11 of them with different small brokers and everything. And once every 2 years or so, Lawyers Title, which no longer exists, flew in this guy from Philadelphia who was a nationally recognized expert on affiliated business arrangements, and we would meet him out at the airport. And he would go over our business models and our financials to see that what we were doing in each of those affiliated business arrangements, crossed every T, dotted every I that was required by us. Then, by the way, CFPB came along and decided that none of the HUD guidance on all of that we had been working on with for 20-some years applied anymore. CFPB was the new sheriff in town, and they were going to prosecute and fine people however they decide the laws meant, and they did it for activities that predated the CFPB's formation. So there was this law firm in Louisville, Kentucky. I knew them well. Borders and Borders is their name. And Borders and Borders had a bunch of these affiliated settlement companies. I used to go to national conventions and run into them. And in fact, Borders taught for the Louisville Realtors Association, their real estate law classes. And CFPB decided that what Borders and Borders was doing violated CFPB's new interpretation of rescue. And they spent a couple $1 million trying to defend themselves over 6 years. 6 years, 7 years before the case was dismissed. Now, when the case was dismissed, could they come back and ask the government to reimburse their legal fees? No. So this is a problem, this is a challenge. And how you're gonna offer this and make sure it doesn't violate. An ounce of prevention is gonna be worth a pound of cure in doing this. Get the advice in writing, get the advice in writing confirmed, and then do it. You don't want to be Borders and Borders. All realtor MLS participants in every state are now going to be required to enter into written agreements with buyers with whom they're working, unless it's going to violate state or federal law. And those agreements have to clearly disclose all compensation with the realtor and sources. We have that already. Actually, I went back and looked at our standard buyer agency agreements. They meet these requirements perfectly, and they've met these requirements for what, 10 years? Excuse me, by the way, I have allergies, and this is terrible time of year.
You want some water?
If there is a bottle of hot water, out of the. The NAR settlement agrees with realtors and realtor MLS participants are prohibited from representing, thank you very much. Representing to a client that brokerage services are free or at no cost to the client, unless they receive no compensation whatsoever for those services from any source. So Pennsylvania has not really enforced that, you know. You've been able to say to people, I'm having you sign this. But most of the time, the properties that you will buy will be listed on the multi-list. And most of the time, the commission that you're agreeing to pay me will be paid by the seller, and you're not actually going to have to pay. Now, it's only that you can represent you won't have to pay if you're not going to get anything from any source. You have to say, this is the amount of money that you're responsible for paying, unless somebody else pays. And the word free, or the word you won't have to pay, shouldn't be in your discussion or presentation. I think that's going to be one of the things that's going to require some practice. And probably some sales meetings and how this is going to be presented. What can you say, what can't you say? Because that's gonna be something that individual consumers are going to be sensitive to. As a result of publication of all of this, the money people are getting. So, I mentioned this case in State College. There were over 100 complaints filed against my client, who is a landlord. The Attorney General's office thought, where there's smoke, there's fire. If there are 100 complaints, this guy must have been doing something terribly, terribly wrong. What actually happened was there was this young lawyer who was working for Penn State Legal Services, and he told all these student tenants that if they filed a consumer complaint against their landlord, they'd have a good chance of getting some money back. Their security deposit for cleaning, or extra charges for utilities, or charges for damage like broken screens or broken cabinet doors in the kitchen. All those things, you might get the money back that has been taken from your security deposit, or that has been charged to you for these things. So out of 6,000 tenants, 4 tenants times 300 units would be 1,200 a year for 6 years, would be
7,200.
7,200. Out of 7,200 tenants, 100 of them, 100, a little over, maybe 110, 115, filed complaints. That's not a high number when they're given that incentive, right? What I'm concerned about right here is this is going to be the point on which the buyers have memory loss. They're going to forget that you told them that they have to pay. They're gonna really, really want to remember that you told them it would be free. Because maybe if it's free, they can get some money. That's why I think you have to program. Here, required realtors for sellers and MLS participants to conspicuously disclose in writing to sellers and obtain seller approval for any payment or offer payment the listing broker will make to another broker before payment is made, specifying the amount and rate of the payment. So that's the other thing.
Don't we already do that?
Well, you have to ask permission. Seller by seller. I'm gonna ask you today, I'm listing your property. Now, I am going to show a commission of 5%. If somebody from outside, or even another agent in my company brings a buyer, I want your permission to share that with them.
Well, isn't that the listing contract, right?
Well,
When you say 4%, 3%,
but you're not going to be able to do it without actually having the discussion, actually going through and getting very specific permission. And there are sellers who will say, wait a minute. If you're gonna share it, and I've read this stuff that says you don't have to share it. I don't want you to share it. I want to pay you 2.5% and don't share anything. That, I think, is what we're gonna have to deal with. At the upper end of the market, particularly, the people who read the Wall Street Journal and the discussion of how to negotiate real estate commission under these new rules are gonna be excited to try to do that.
I had this conversation with 370,000. Like this exact conversation,
With how many?
the seller on our house.
On a $300,000 house?
Like a 380.
Recently, after they read about it,
Yeah,
okay? And how did you resolve it? I put you on the spot?
yeah. I mean, I told him, I understand you don't have to offer this, because he said, I want to pay you 3.5, that's it. And I said, oh, okay, that's fine, you can do that, that's up to it's technically up to the buyer's agent to resolve any discrepancies with their client on that, you're good, but just let me know when you really finally decide. Come back weeks later for photos, you can pay the buyer's agent. Whatever, because I don't want to lose buyers essentially.
Yeah.
But he came to that on his own resolve. I was prepared to write a listing contract together with just myself and the babe. So these conversations.
So it's not just coming, it's here.
Oh, yeah, it's.
Yeah.
And we all have to be ready to deal with it. Now, a lot of this stuff doesn't go into effect until July, and it will work its way through here, when West Penn decides, that they're going to, agree to, be bound by it. But the idea is obtaining seller approval and proving that you have obtained that seller approval to share creates that opportunity to negotiate a one-sided commission, which sellers are going to try to do.
When they finally make this official in August or whatever, is it gonna be retroactive, or people in the past gonna be able to ask for refund?
No. That is an important part of settlement. Most settlements are intended to be prospective, not retrospective. We will agree to settle going forward, so we don't have to face claims going backwards.
Now, this is, the important thing about that conversation was all about that seller's past experience or buyer. So I think as buyer's agents, the perspective needs to be to make sure that articulating the value of being a buyer's agent is important, because the only reason why he didn't want to have to pay a buyer's agent, because he felt his buyer's agent for this house didn't do enough for him.
Well,
Yeah.
and the other thing that I've heard from, because I get a lot of discussions from people who know I'm a real estate lawyer who ask about this. And they're saying to me already, well, I never understood why I, as the seller, should have to pay the buyer's agent. Why was I not paying my agent? Why was the buyer not paying the buyer's agent? And my answer actually has been, and you're gonna be surprised, the buyer paid all commission on your transaction. Why? Right, they bought the house. Did you write a check out of your checkbook to pay your agent or the buyer's agent before closing? Well, no. Okay, so the point is, buyers in this state have been paying both sides of the commission. And it has been included in what? The purchase price of the house. Right? But that buyer has not had to show that as a direct payment. It's been an indirect payment. And it is reflected in the basis that they have in their house. Now, the basis in their house doesn't matter for most owner occupied, because They don't have to worry about their gain unless they're at the really high end market. However, for non-owner occupied, basis matters a lot. And the commission ends up being built into their basis because it's in the purchase price. So that means that when they sell, that's not gain on which they have to pay tax. Yes.
I also make it a big point to let them know that like they're cutting out on a huge pool of buyers, if they're not offering VAC, VHA.
Oh,
And
we were gonna get to that, absolutely. Okay, and we're gonna talk about how we should talk about some of these things.
You guys have to buy or sellers, try not to pay the buyer.
Not yet.
I had somebody bring it up, and I make the same argument all the time. The point is, the hardest part for a buyer, usually, your standard buyer, not your exceptionally wealthy people, but your standard buyer, is the cost associated initially upfront buying a home. By increasing that cost, you are lowering your buyer
Yeah.
significantly. And by doing that, you're gonna have less people through your door.
And the other problem that we're gonna get to is when the real estate commission paid by the buyer is included in the purchase price of the house. And it is supported by the appraisal. It is part of the finance. Right?
Say that again?
part of the finance.
It's part of the financing. So if I'm paying $100,000 for a house. And the seller is nominally paying all of the commission, the $5,000 or $6,000 that's going out of that $100,000. Is still part of what I'm paying for the house. So if I'm getting an FHA or VA or, a 5% down mortgage, I'm only having to come up with 5,000, to your point. Or less, depending on what the program is. However, if I as a buyer have to pay your buyer agent commission, and your buyer agent commission is $2,000 or $2,500, I have to pay that in addition to paying $5,000. So now I've increased the amount that I have to come up with by 50% or $2,500 when it's hard for me to get the 5, let alone the 7,500. And to your point, that shrinks the buyer pool.
I mean, on the VA loan, they don't even allow you to charge a broker fee. So that would be, the
Right.
VAs would be impacted.
The VA is gonna be impacted. That's right.
But wasn't the seller commission, which was negotiated with their listing broker, always the cost of doing business, like the transfer tax? The municipal lien letters?
Well, it's a cost of doing business, but the difference between the transfer tax, the lien letters, and the commission is these two are not negotiable. This one, in theory, should have been negotiable, and as a result of these things, they think it's going to be negotiable. I don't think so. We'll get to that. So I'm jumping ahead.
Brad,
Right.
Susan has a question.
So, yeah,
So right now, the house has to appraise.
right.
So if the house has to appraise at a certain level that includes all the commission, okay? What happens when it doesn't include the buyer agency?
It still looks like the same price.
Well, that's the same.
The appraiser doesn't-
And so
The
the
appraiser doesn't.
the idea is,
I mean,
remember, they thought that realtors all over the country conspired to increase the commission so that sellers and buyers were unfairly taken advantage of.
But Brad,
So they're gonna solve it by saying you can't disclose, except on your own website, on your own listings, what you're willing to share. And you have to get seller permission for any sharing. And everybody, sellers and buyers, have to know the details of how all this is gonna work very, very clearly. Now, I think in Pennsylvania, they already have a pretty good idea from our existing documents, and I don't think there's a big deal. There are a lot of states where they didn't require buyer agents to even sign with their buyers. And so it was like, ooh. But all of that is going to be more in line with us. What all companies and multi-lists and NAR participant educators have to do. They have to change existing rules of associations that are inconsistent with this settlement. So all the rules are being changed. Develop educational materials to reflect and be consistent with each of these practice provisions. You can check one of those off today, right? And eliminate any educational materials that are contrary to this. These practice changes do not prevent offers of compensation to buyer brokers or seller concessions to buyers, as long as those concessions are not limited to or conditioned on payments to buyer brokers. So they contemplate already that if buyer has to pay the buyer's broker directly, the seller can issue a 2%, 2.5% concession. Now, you can't say that the concession is limited to or conditioned to payments to buyer broker. But it doesn't say it can't be exactly the same percentage. Does that make any sense?
No.
So you see, remember I told you this is over-inclusive and under-inclusive. This is one of those things that you're disclosed as long as you don't say it is quid pro quo. Remember that language? As long as you don't say it's quid pro quo, one thing in exchange for the other, that's all that really means. Then it's okay to have that concession. So that's another one that buyer agents can be compensated.
So Brad, was that the, so, I'm just trying to, yeah, that's what I was getting ready to say, when you sell assist.
It's basically a seller assist to allow the buyer to be able to pay their own buyer agent commission. But you can't say that it's conditioned upon them paying their buyer agent commission.
Now, does that, if they do that, is that 2.5%, like for an FHA loan, the max you can get is 6%, is that included? So if they're already getting 6%, they can't get that?
FHA is gonna have to change its
Right.
guidelines
So that's-
pretty clearly. VA, FHA are, they weren't involved in drafting this settlement, right? And in times when interest rates are higher and buyers are tight on cash, how else do first-time home buyers get into the market? So clearly, it's a problem for first-time home buyers. I also think that part of this over-inclusiveness of the settlement is that we don't consider the effects in markets like ours, where there are still lower value properties and there are buyers who only qualify for those lower value properties, but it gives them the opportunity to own their own property. And I'm gonna make an educated guess that installment land contracts are going to be used to develop the buyer's ability to buy when they don't have much to put down. If these changes interfere with buyer agents. But before we get to that, these practice changes, everything we just went through, lasts for 7 years.
That's my question, because this has come out when it's complete seller's market. So when we turn to buyer's market, where the seller have a trouble to sell the house, will that change? Like they're gonna have another settlement?
For 7 years, all these things
Again.
all these things are going to stay in place. After 7 years, whatever changes there have been to the market, the settlement is over. The money's paid, all these practices don't have to continue. I know that the plaintiff's lawyers, the plaintiff's lawyers don't care. Why?
Looks like they'll pay.
They're getting paid out of the 414 million.
For 7 years, not joking.
Well, they're getting paid over 3 years, which is really 4 years. So they'll be paid before these go out. But this is the, what is it, the Cinderella effect. You know, when midnight hits, the coach turns back to a pumpkin, right? And the idea is you've got 7 years in which NAR, local associations, all the major brokers have the opportunity to see what works out of these things, what doesn't work out of these things, and change. To your point, I hope the market doesn't change dramatically during the 7 years when we're stuck with these rules, because they could really be impediments. And it's a settlement agreement, it's not a law.
Yeah, actually, that ties into like, and I'm curious what your thoughts are. There's another settlement proposed, or not a settlement, but a lawsuit, the MLS pin up to Massachusetts, where the Department of Justice, they've completely like this whole NAR settlement proposal was not really what the Department of Justice is even.
That's right. And you remember on my first slide, it said that in addition to these cases,
Yeah.
the Department of Justice investigation is
Yeah.
still ongoing, and it can come in behind this settlement and change everything.
Yeah, it makes me wonder if it's even going to get to that point. I'll be surprised, like if they
Okay,
let
it's an
this-
election year.
That is
It's
true.
not gonna
It's
happen.
true.
I'm gonna predict that it's not gonna happen between now and January. We're not gonna hear one word about the Department of Justice investigation changing this. Depending on what happens in November, I think we'll see something early next year. What we see will depend on what happens in November. I think that congressional action is something that is a decent possibility. Because now you've got all these lawsuits that resulted in a settlement. And where was Congress? Asleep at the wheel. They don't want to be seen as asleep at the wheel. What can they do to help? Will it help? Will it harm? You know, but I think executive action, investigation by the Department of Justice, congressional passage of new laws are all possibilities. But all we can do is focus on what we have to focus on. And know that every one of those other avenues is a potential for change that could either be good or bad. But in the end, whatever bad effects there are on consumers that come from settlement, somebody is likely to try to fix.
So you mean the PAC gonna be existing for the rest of the year?
The VAC
On the multi-level?
will, as soon as West Penn decides to follow this, and look, it's my opinion that they've got no choice but to follow it. And I had a call in last week to Fred Judd, who represents West Penn Multi-List. I talked to Terry Wright, who's of counsel to my office now. I also talked to Brett Woodburn, who I work with at Ramp, and at least the three of us all believe that West Penn Multi-List is really not going to have a choice but to adopt. But Fred hasn't come out and said that, and I haven't seen a statement from West Penn Multi-List that they have reached that determination. I get it, they don't want to, but I think we're gonna have to. So, but they're not gonna win, so it's not automatically covered, but if they don't adopt the settlement, they'll likely be sued by lawyers, copycat. And so most of them are expected to largely win the settlement. And I've seen statements come out from other places where non-affiliated multi-lists have already approved. They just don't want to be sued. Yeah,
I know that commercial is not consumer.
right.
How do you think it's gonna affect that?
Commercial agents, commercial brokers say, we don't care. And the question is, will commercial buyers and sellers want to negotiate? Many commercial buyers and sellers are sophisticated enough already that they cut their own deals. I've seen so many. Hey, my brother in Illinois is a broker. I'll pay your commission, but you got to share it with my brother in Illinois, right? That's what we see in commercial transactions all the time. Some broker somewhere, California and Illinois, ends up getting a piece. And they have the right to pull it back to, I just had a commission dispute that we went to mediation on, where a big law firm rented thousands of square feet space. And the only way they would rent it is if the landlord paid a commission to their California brokerage that supervises everything they do, even though they're not licensed or reciprocally licensed. But we ended up compromising on it, and my client said,
Seriously.
Sure.
Guaranteed.
So on some commercials, on the commercial listings, I use a lot of nationwide, like Booking and CoStar. And they actually kind of, everybody in different states can see the national listings. And they don't really have to have a people in that state to go to the multi-list. And then they never listed their commission for buyer or buyer agent, or the tenant agent, whatever, for commission.
Right.
So that how that works is, most of commercial deals, their commission rate is greater than 6%. And so the seller agreed to pay for it. In a lot of cases, the seller agent gets able to be due agent. And then sometimes they have, other big corporation, they have their very big department. And then they were coming, so if we want some of the commission too,
Right.
so we can pay.
oh yeah, the buyer agent drafts the agreement to include specific provisions that buyer agent's getting paid and somebody somewhere else is getting paid.
Also, a space or commercial deal, I always put my commission for there. If I be presenting on the buyer side,
Right.
I say, televisions require minimum 3% of the commission on this deal. So I always put it there as a proposal, part of the proposal, that's why.
So in effect, it's being negotiated.
So can we put this on the sales agreement, like a buyer agent require the seller to pay buyer agent 3%
Type it in,
on the sales agreement?
that's an offer, right? And those are the very specific terms of the offer, which if it is accepted, everybody will have notice before they accept it.
Take it a step further to, what I've been learning to practice through thinking through this and talking with different people in my company is, putting in the BAC, buyer gives permission for agent to request compensation from seller, which then is another.
And you're gonna get, I expect, your franchisor is gonna give you very specific instructions.
We have,
On exactly how you're gonna wanna put that in there as soon as this becomes effective. And now is our time to learn what they want, to make sure that you comply. Yeah, look, I always tell people when I teach classes that I don't shy away from giving you my opinions of what the law is, what it should be, what it isn't. But you have an obligation to make sure that you follow the directive of your broker, your broker's counsel, and your franchisor's counsel in this case. Even if their opinions don't match mine, theirs are the ones that guarantee that if you follow them, you're going to be defended in your actions. So it makes sense. So now we get into what can agents do going forward. I think this is a very important part. Individual agents are not bound, but will likely follow the industry. Most brokerages are expected to have agents explain to sellers that offering buyer broker compensation will increase traffic. I've actually seen this in instructions to 3 major brokerages. Offering buyer broker compensation will likely increase traffic, reduce time in the market, and improve sales prices. You all agree with that, right? The wider your market, the faster, the higher you're likely to be able to sell. Now, I think it's very important for all of us to keep statistics on transactions under these new guidelines. Because that first statement is reasonable, but it is speculative today. Because we don't know how this is going to work. But in the next 6 months, by the end of this year, we should start to have data, real data on how it's working. And look, I would always rather tell people, you know, the statistics in arbitration are that I have a 90% success rate if you follow my advice. Then, you know, I think I've got a 90% chance of winning your case, which sounds better, right? So the faster we develop anecdotal evidence to begin with and statistics to help over the next 7 years, the better we're going to do. We've had in our office X number of transactions where people didn't offer, and those homes sold at an average of X%. of their assessed value. And that's a good measure. Conversely, where we offered buyer agent commission, we had many more homes and they sold at 1% of assessed value average of. And that spread between X and Y is a good statistic.
Because assessed values are pretty accurate.
Well, they're the only measure we have. And look, the calculations that go to state tax equalization board every year that result in the numbers for each county's ratios for assessments. They're not great, but they're better than nothing.
Sure.
And they are at least an independent set of numbers. So, I mean, you could use a different set, but I'm just saying
Yeah.
that one came to mind. Statistics, wherever you develop them, statistics are gonna matter. Brokers can refuse to work for inadequate commission. Just because it's negotiable doesn't mean you have to say yes when I offer you a $500 commission to sell my $500,000. Right? Why would you do that? And this, by the way, is where I think is going to create pressure. Hiring buyers will be able to and likely willing to pay brokers for buyer agency because they will know the services they want. They will know the cost of those services, and they will have been through multiple transactions where having a good agent made a difference, right? Somebody on a $2 million property wants a good agent to help. First-time home buyers, FHA, VA, as we talked about, and other low-end buyers may not be able to pay for buyer brokers. Many of them, if those properties are listed, and I envision that on the $50,000 listing, there are going to be a lot of agents and brokers out there who are going to list, and they're going to take and say, I want my $2,500 minimum on this. I don't care what anybody buyer's agent gets. You go ahead. I'll get my 2,500. When this sells, it will sell to somebody at some time, and we're not going to share. We're not going to offer any buyer agent commission. And then those buyers are going to come in, and they're going to want to, well, I don't have the extra money to pay you separately. What am I going to do? I think some of them are going to be driven to say, okay, I'll just deal with the listing agent. Now, don't get me wrong. I don't think the listing agents are really going to be thrilled with that because they're used to, over the last, 20-some years, having a buyer agent handle inspections and explain things and do all that kind of stuff. And they're not going to want to do twice the work. So I think there's going to be this dynamic going where there will be a lot of lower end listings where agents refuse to share commission, taking the justification from this. Nobody can make them do it. They're locking in at their 2,500 and whatever it is, and that's all that seller's going to be willing to pay. And then those buyers are not going to have representation. And that's not what this was intended to do. But that's what I referenced earlier as the unintended over-inclusive result.
Can we say, okay, I'll do it for X% as a listing fee, but if I am dealing with a buyer on the other end and not a an agent, can I charge an additional transaction fee?
You can negotiate with your seller.
Yeah.
Your listing and your commission rates. You can do it with their permission, right? You can have different prices for different things you do. You want me to do this? This is the price. You want me to do this and this and this? This is the price. I think we're gonna see some à la carte offerings. And I'm really expecting that those will develop out of New York, California, Boston, and Chicago, markets where this little tiny property is already at, you know, $500,000, $750,000, and those sellers are gonna say, I wanna pay less in commission. And those agents are gonna respond that you wanna pay less, I'm gonna do less. Right? So that's where I think the a la carte stuff, I don't think we're gonna see a lot of it here. But I do think a la carte services may become more common. I think higher end sellers will have the sophistication to read disclosures and negotiate lower commissions. But then if they're not selling their house because they've refused to pay a higher number that gets shared, they're gonna have the sophistication to understand. So in the end, what I'm anticipating is right now, we get from this point to this point in a pretty straight line. Under these new rules, I think that most of the time, we're gonna get from this point to this point, but the steps to get there are going to be more complicated and have to be carefully negotiated. And I mean that negotiated, not just negotiate, explain to sellers, explain to buyers, written, careful about making changes to accommodate things, know these guidelines, know your company's policies very well before you start negotiating. Hey, if you're bringing a buyer agent, we'll agree to cover this if and only if the buyer agent's getting paid. That if and only if better not be in there, or you're gonna have a problem. That's the kind of thing I worry.
Well, what if you're discussing the listing contract with a seller? You have to negotiate the agency ahead of time? Do you have to say-
Well, you're going to have explained, you know,
Say you find the buyer,
but you're going to have to explain dual agency and all that when you go through your listing presentation.
yeah, we always
Yeah.
do, but.
So I don't think that's,
Pay the seller side.
now you're going to negotiate. Well, the tip, by the way, that has come out of a bunch of other lawyers is somewhere they said negotiate, and I thought I had the slide in there, but I don't see it on there. Negotiate once your commission. Is it 6%? Is it 5%? Is it something else? When you're done negotiating, you're done negotiating. Then say, I want your permission to share or not share. And the bottom line is, if you negotiate your commission first, and you're done with that, why would your seller care? If you're negotiating and you put the cart in front of the horse by negotiating your share before you negotiate the total, you're likely to get less. Only makes sense, right? All right, so now I know that was the last slide. I ran over, I apologize. I thought this would be about an hour and a half total of questions.
I thought it was about 1:30.
Yeah, so.
Yeah.
Wait, it's still 1:30, because I figured if y'all had questions,
Oh,
it's
good.
been going along.
Well, I apologize if I'm here. If you have any other questions, I'm happy to address them.
Thank you.
Thank you.
And this really was a great space.
This is great.
I love that curved screen too.
I have some questions.
Yeah.
This is our like team of four here. I'm the only one that's a realtor.
Okay.
So you're not a realtor, you're technically not covered, right? How do we make sure that,
So the answer is under RELWA. Only you can do the things that require a license. And disclosures and negotiating are all part of it.
we're licensed, just not a member of NAR. I'm a member of NAR.
Oh, okay, well, I thought you had non-agent employees of your team. Saying you have agents. So the answer is KW is part of this. So you're going to get, look, NAR published the details of its settlement. I read all that, we discussed it with other lawyers. This PowerPoint comes section by section from the provisions of that settlement. I don't have a copy of KW's or Reology's, or they have them. Each of them knows what they agreed to. They each likely agreed to money. And they each likely agreed to follow a similar set.
So I guess since we're with KW, we're protected from future litigation since they settled.
Yes. KW's protection and NAR's protection from future are there. And assuming West Penn jumps in, you'll have 3 layers of that protection. Yes. Is that, well, that's the term of the NAR settlement. And the question is, who's going to do what after that? Remember, there's a statute of limitations on each of these individual claims. During the next 7 years, any available statute is going to expire on all the things that have been done up to now. All the things you're doing going forward are going to be in compliance with these settlement agreements. So 7 years from now, who's going to be able to sue you for what? I mean, you know, there's the old statement you've probably heard, you can indict a ham sandwich, right? Anybody can sue anybody for anything. The question is, how far along do they get in that action before it's tossed? And how successful is it in the end? And what I'm telling you is, in 7 years, you might see some lawsuits come up, but nothing's gonna end up with a $1.8 billion settlement, because everything will be tightly regulated. And I'm here telling you to cross every T, dot every I. There are presentations like this going on all over the place. Most agents are going to cross every T, dot every I. And those who don't are gonna end up being singled out. Not everybody.
That was kind of gonna be my question, is, I guess we've all dealt with like, and even like, is probably the rules are just lazy. Do you think the masses are paying attention and are understanding, or do you think the roadblock to be agents that misinform their clients or roadblocks?
Yeah, that's a great question. Are there gonna be agents who don't pay attention to this? Absolutely.
Yeah, but there are consumers who don't even.
Right,
Who don't even
right.
understand.
Well, but how many consumers more and more are hearing about it?
They're hearing about it, and they think that I can't, they think my commissions are affected. It's like. I don't really understand what.
Hey, I wanna sell my house, but I wanna pay you 2%. That's what they think,
Yeah, right.
right? And it's negotiable, I wanna pay you 1.5. But what they don't understand is you don't have to say yes. And
But I think that's what they think.
why would you say yes? Hey, look, I have the same situation. I have clients who in the middle of a lawsuit decide they don't want to pay any more legal fees. I pay enough legal fees now. You can just do the rest of this case or not. And you know what the judges say when we file our motions to withdraw from representing them? Indentured servitude in this country ended in the 1860s. Now, we're not gonna make that lawyer represent you for nothing. And people say, oh, but I thought, right? And that's the same thing you're gonna face. You're gonna have people who hear about this and think because they have the right to negotiate, they have the right to set your commission. You have the right to say no. And what agent, anyone, is going to agree to that? Sell my $500,000 house for $500, right? No. Now, that doesn't mean people won't try. I get calls all the time saying Edgar Schneider takes cases on a contingency. They want me to take their $10,000 case. They could take $5,000 worth of my time for a 25% contingency. I said, I'm sorry, I can't do that, won't do that, but go ahead, call it. Right?
Yeah.
He won't do that either. Well, now the partners who took over his firm won't do that. Because they know very well who the insurance carriers are, what those carriers will pay. They know details on the injuries, damages before they say. They know they're gonna get enough money to cover themselves in 90-some% of the cases. And you have a right to know that you're gonna get enough commission to make it worth your while. And you don't wanna lose sight of that.
Well, and that's the thing, with this only talking that we have to be more articulate and understand our value a lot better.
And
Communicate.
it's your job to explain what this settlement is and what it isn't. Because a lot of what's out there is misinformation.
Buyers are gonna save money. Like what?
You know, I mean, just like in those depositions in my case in State College. At the end of each of those former tenants depositions, I stop and I ask them. Are there any questions that you still have about this process today? And you know what, about 30–40% of them said? Yeah, I do have another question. When am I gonna get the money that those people told me? The answer is second. That's not something I can help you with. But that misimpression has stayed in these people's minds for years. When am I going to get what I think I should? And that's why are you not going to represent me for a small fraction of what you would have before? Right? That's the question you're gonna have to answer. You're gonna have to fix that. And by the way, a couple of hiring agents have asked me if it would be okay. They shared the whole NAR settlement with their high-end buyers. We should, sure. Why? They're not gonna read.
Yeah.
They're too busy to read, what, 57 pages or 77 pages. And even if they read it, they wouldn't understand it because they're not in this business. You know. So I wouldn't be afraid to share information to help to convince people that you actually do understand. Right?
Yeah.
Here's the settlement. It doesn't say what you think it says. I've read. I've attended a class on it. We've had great discussions in our office on it. We've received direction from our broker on it. We're ready for this.
So what's your best guess of how buyer agency commissions are gonna be advertised? Do you think each broker is gonna you're gonna be able to click on it and there's gonna be a list of all their properties? It's gonna show.
I think on individual broker sites, that's why I highlighted that, they can do it. Why wouldn't they do it? To cause more traffic on their own listings. Broker sites, instead of, by the way, all of the, third-party sites.
Yeah.
I think this is going to be a problem.
Yeah.
This is gonna be a problem for the third-party sites. It's also gonna be a problem for brokers' copycat sites. Unless they get specific permission. Hannah gonna ask Keller Williams for permission to list. Then are they going to put your listing on their website? If they copy your listing, it's gonna copy your permission, and then it doesn't say they can do that.
Yeah.
See? So I think that the copying is going to be an issue. Until there are a bunch of agreements that all these lawyers agree don't violate this. I think we're gonna see individual sites getting a lot more traffic.
So you're basically saying the boutique shops are gonna suffer from this.
What's that?
The boutique shops, the smaller shops.
Yes, because when you go on their websites, they have 3 listings. But consumers don't know that they have 3 listings because they're showing all your listings. They're not going to be able to show your listings with your commission share anymore. They're not going to have the technology.
Was
to
they
filter
still
that.
able to show our listings on the website?
If you agree, MLS listings will be there, but they won't have
It won't have commission on that.
commissions.
Like, we can't put a Hannah listing on a Keller site that shows.
Right. You only put Keller. And there's even a question whether you can put a Keller listing from a different Keller franchise. Man, this is gonna be complex for a while.
There's been some discussion, say we have 3 houses that show a buyer. We're gonna have to call each listing agent to find out if they're offering buyer agent compensation, and then tell your buyer before you see the house. Okay, this one's not offering, so you're gonna have to pay, what we agreed in our buyer.
See, that's a thorny issue.
Yeah,
Here's why.
focus is all on us instead of the house. They're gonna put in.
Well, and the whole design of this is that you're not supposed to only show the properties. Now, this reminds me of the predators list. Okay? What do you call that list? Sexual predators list?
Oh, Megan's law.
Megan's Law, thank you. When Megan's Law first came out, I advised agents not to get in the middle of the street. Tell your buyers, it's out there. Tell them where they can go to look up all this information. Tell them they need to look up the information before you make an offer for them. But let them do it on their own, because the moment you do it, you're gonna find out things you didn't want to find out. I went on there and I realized that my neighbor across the street, whose brother came back from Japan after serving in the military, had actually been convicted and been jailed for molesting 13-year-old girls in Japan.
Oh,
And now he was living across the street. And my wife, my daughter lives up the street, my granddaughter lives up the street. A lot of the other neighbors are my friends. There are a lot of little kids. That was information that, when you deal with it, how do you deal with it? When you find out, you know, now I know that. You know, you can't unknow that stuff. His brother moved out after about a year. Got a job at Walmart, by the way. But you can't make these things up. In any event, the point is, that same kind of shift is what I think about. For, hey, this is your deal with me. I'm your agent. I'm your buyer agent. If somebody else pays my commission, I'll take it from them. If they won't pay it, you owe it. I'll show you all these homes. Many of these brokers will list on their own websites what they'll pay me. I'll show you every home. I don't care, because one way or another, I'm gonna get paid. You decide which of these homes you want to see. Now, the beautiful thing about that is if they don't want to have to pay you directly, they're making the decision, they're doing the research, they're deciding which homes they want to see, and you're not steering. No steering allowed. It's like you're driving a Tesla, right? So, you know what I mean? I think that Megan's law advice is gonna work for buyer agency pretty well. Because what else is on those what else is on those listing sites that isn't on everywhere else? That'll be the only place where they can find that information. But if you do it for them, you could be accused of steering. If they do it on their own, they can make their own choices. And I think it will drive them to say, there are these two houses. This one I have to pay $5,000. This one I don't. I want to see this, right?
So when did you think, oh, I'm sorry, when did you think this kind of change will start?
July, August is when it's all gonna roll in.
So what happens when they go, well,
Yeah,
I wanna see that, and I'm gonna call the listing agent directly and kind of break their agreement with you.
but you have your buyer agency agreement with them. And the question is, the question always is,
Do we wanna?
if
hire
your
an attorney?
buyer breaks your buyer agency agreement, is your broker ready to enforce it? And most brokers don't want to enforce them because they don't want to spend all this time and money
Right.
when they can be on the
Well,
opposite
it's
side.
up to us to go after them and pay the attorney fees. Because the broker's not gonna do anything.
So that's the one drawback to, but look, honestly, if they go on a Trulia or Redfin or any of those sites, they can see who the listing agent is. So how does going on Hannah's site for a Hannah listing any different than seeing that on your site or Redfin or Trulia or anywhere else? The only difference will be that commission. they're not gonna get, you know,
So I get on the commercial side, I get a lot of calls from people that wanna buy. And the reason they call the listing agent is because they figure they can negotiate, you know, a better price and a better commission, that type of stuff.
So Susan, I agree
Wait.
and disagree.
Susan, does it work?
No.
Okay. But you get the calls,
I get the calls, but it doesn't help me to close those people. So that-
yeah.
But no, I agree to disagree, because them first time home buyers, you're ruling your client's day.
Well, she was talking commercial.
Yeah. But I mean, like someone who's a little more savvy,
Yes, they
Yeah.
do us.
okay, there might not be first time home buyers, they're not savvy, okay? But anybody else that, you know, you're trying to sell, you know, a $300 or $400 $100,000 houses to, they are a little bit more savvy and they're gonna start doing that type of stuff.
So you'd have to be ready, to your point, to have the knowledge, the information, and your explanation of that knowledge and information ready. And I think that's really gonna be what it's all about for the rest of this year. By next year, we'll start to have data, information, and more shared advice and experiences.
Well, I think this is just a way for us to enforce that with professionals, like, no other industry really questioned this wholeheartedly, whether we should get paid, that's not, like.
Well,
I'm not saying that.
no, to be fair, I have the same criticism of lawyers on contingent fees. So a $10 million case where a lawyer has spent 10 hours to get 40% or $4 million is $400,000 an hour. Did I do that right? In 10 hours to get, yeah. On a New York $15 million condo, where that agent has spent that much time
Yeah,
to get that much commission.
but that's where I understand this.
Well, and I think that's where it comes from. And I don't think it really applies here. I don't see any of you driving Bentleys. Anybody own a Bentley? No.
Genius.
You know? You know who owns a Bentley? A client of mine who owns, well, he passed away 2 weeks ago now, but owned 10 big office buildings. He worked his butt off for many years as a real estate investor. And finally, he got his Bentley. He didn't get to use it as long as he would like to, but the point is, that's not you and me in this area. Because real estate commissions and, you know, deeds and title insurance and all that are on a more normal set of numbers. But we all are faced with the national what's happening, and that's why I think, you know, it's the low end of the market that's really going to be affected by this.
Which is why, like, I feel like the sentiment is we're trying to save people. I just think that less amount of people are saved from the situation.
There's common sense arguments and discussions to be had around that too.
Mhm.
If you have a client that's gonna do that, and you say to them, okay, fine, you wanna save a couple dollars, but then you're putting your whole investment in the hands of someone you don't even know, who is trying to close this deal.
It's the
It's
biggest
scary.
investment of your life.
You may lose more in this deal than what you were repaying. That's period. It's common sense stuff.
Well,
There's also conversation around dual agency, like you're gonna go work with the listing agent, who signed the fiduciary contract for the seller, how do they have that?
and I like to say, if you're working, if you're a buyer and you're talking seller's agent, and you say, I want to offer $100,000, but I'd be willing to go to 120. That agent now has the fiduciary duty to get you to 120.
They're gonna know what you're.
That's right.
Yeah.
And buyers who are working with seller's agent or listing agents are not gonna understand that they don't have anybody in their corner until they experience it.
If you do the analogy comparing this to a game of poker, you're basically saying, show one person both hands.
Yep. That's a great analogy. I'm gonna borrow that.
That's, on that note, I gotta.
So the-
Yeah.
I'm thinking about case, the listing agent maybe get 5-6% commission,
Mhm.
but decide not to share, since the buyer agent, they know buyer agent might have some kind of buyer agency agreement with the additional 3%. If they don't share, so we probably come up with a transaction, the listing agent gets 5%, and the buyer pays another 3% to the buyer agent, the total commission becomes 8%. So that, is it something you think that can happen?
I don't think that's going to happen a lot. Because sellers are going to start to realize that they're ending up paying more. And buyers are gonna realize that that whole structure doesn't work. That's why the buyers are going to look at the websites that list your KW listings, show your commission. Buyers are gonna look at that and say, okay, you will pay. So I don't, your seller will pay, so I don't have to. I like it. It makes my money go further on the price of the house, right?
But what happens to the HUD? You know how in the HUD, it says the commission is da 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 da.
Well, the answer is, so most of them now are gonna be the CDs. I like that you've been in the business long enough to call it the HUD, because I do too. And oh, well, I like the HUD better because it goes from top to bottom instead of adding from bottom to top. I think they created the CD in China.
Right.
Yeah, but in any event, the idea is whether it's a HUD or CD, it's going to show that the commission paid by seller is paid by seller. It's going to show the commission paid by buyers, paid by buyer. Who gets it is going to show. So if there's a share, it'll show the same way, sellers paying both. If it's not shared, it's going to show the seller's agents getting all of seller's commission and buyer's agents getting all of buyer's commission. But that, nothing in the form has to change, just which blocks the numbers come.
So you can decline to answer this one, but I'd love to hear your view of what next spring will look like depending on how November goes.
I will answer, but I will tell you that as a matter of full disclosure, I am counsel to the Republican Party of Beaver County.
Okay.
Okay, I volunteer, but so
Okay.
my
Appreciate the
analysis, yeah, so, you know, you can't give an opinion without an understanding of where you're coming from. But my analysis of that is that I think interest rates are gonna stay pretty stable from now till November. I believe that there is a risk that interest rates are going to go up next spring. Further, if certain policies don't change. And the likelihood of those policies changing depends on two changes, not one. It depends on a change in the executive, the presidency, and depends on whether there's a change in Congress. Right now, Congress is just about deadlocked. I mean, yeah, it's so close. And actually, I often believe that deadlocks can be a really good thing, because if they can't push policies too far one way or the other, the bottom line is the market drives things. But as soon as you try to push policies too far one way or the other, you have unintended results, like that over-inclusive and under-inclusive talk about. You know, or the old adage of throwing out the baby with the bathwater. You likely are going to see changes. And I've been watching Wall Street with the polls. I see a correlation between stock market going up when more polls are coming out that indicate that the race is more likely to go toward a change. And I see the market going down when there's an indication that there's not going to be change. And I find that puzzling, because most on Wall Street actually support President Biden and Democratic. So if they support that, why would the numbers not reflect that support?
Well, I could give you that answer.
Yeah.
Because the last administration kept rates artificially low for 4 years. Right, and they'll probably do that again.
And they would probably do that, but the bottom line is, I care about where the rates are, not as much about why they are.
Yeah.
And in your business, I suspect you care about where the rates are. Now, the amazing thing here in Western Pennsylvania is our rates are up higher than they were. The market is good, except for the fact that there's such a low supply. But I understand that a lot of the people are coming in from other places still, and that influx of people who are coming from other places is keeping our market healthy. You know, I've had neighbors in my development who have sold their homes in the last 2 months, and everyone has sold in a day or two at listing or above. Now, except for the fact that there are too few properties listed, and I don't know how to fix that. If you did,
I have ideas for that.
Yeah.
Well, right, because the increase of rates actually continued that situation, because people don't believe one situation.
hey, that's right,
Right.
the increase in rates caused a lower supply
Yeah,
They should make,
that drove the supply demand curve.
they
right.
should make loans assumable, all Fannie Freddie loans.
Assumability of loans was much more common when everything was decentralized, when there were individual savings and loans that loaned in different communities. And when everything became nationalized, you know, the bottom line is, the brokers who sold on the Wall Street markets and tranches of mortgages just wanted to turn them over and turn them over. And you couldn't turn them over if they were assumable at good rates. So getting back to that, I think would be good. But the problem is those local savings and loans don't exist very much anymore. But in any event,
Sorry to.
no, I
Thank you. That was a very,
I'm open and honest about stuff.
I like it.
Thank you very much.
Thank you all.
Thank you.
Thank you.
Again, for the invite.
Yeah, I'm so glad you made it.